are
Messia Abrenobo Donko.
Mercy Donko and
Erasmus Papa Akote Kote.
Erasmus Kote. And Mountcrest University College,
Daniel
Faculty of Law,
Daniel Adu.
Daniel Adenu.
And Victoria Enchi.
Adu.
Victoria Enchi. Now, ladies and gentlemen, get ready for the very first round of this contest. And this is the fifth contest. In the first round, the rules remain the same. You will be asked 5 questions, and you have 30 seconds to answer a question. There will be only 2 attempts for a major question. If you answer correctly, you will be awarded 3 marks. If you are unable to answer correctly, the question will be passed on to your opponent for a bonus mark of 1. And there will be only 1 attempt at that question within 15 seconds. Are we ready? If we are, UCC and Mountcrest University College Faculties of Law, I wish you good luck. Now we begin with the Mountcrest University College. Attempt as closely as possible to define easement.
Is the right that is attached to land at common law that restrict the use of land or prevent the use of land in a particular way.
Restricts the use of land or
impose an obligation on how the land should be used.
I think that the essential ingredients as regards the restriction of the use of land by another has been established, and therefore I award you the marks for it. We go to the University of Cape Coast, Faculty of Law. I'd like you to mention 2 ways by which the allodial title, that is title to land, interest in land, 2 ways by which the allodial title may be acquired in Ghana. Only 2.
Okay, so we have conquest and then we have the subsequent settlement.
And that is correct. Thank you very much, Mercy Donko. By the same token, I will require of you of the Mountcrest University College to help us with 2 ways in which the allodial title may be acquired in Ghana.
In 2 of the Act 1036, now allodial title can be acquired through compulsory acquisition by the state and also by agreement.
That is correct, by compulsory acquisition and by agreement. It could also be acquired by gifts, by pioneer discovery and settlements, as was mentioned, conquest, as well as compulsory acquisition. Now, to you, your substantive question. Can you tell us 2 ways by which a good title to land may be derived? A good title to land may be derived.
Registration and possession.
Registration.
So a title to land could be acquired through registration and by possession and cultivation of that land for a longer period of time.
Unfortunate. That was your second attempt. I'll pass that question on for a bonus mark of 1. Yes, Mountcrest University College.
As was stated in Edu versus J, possession can also amount to good title if there is no any adverse title to that. And also when there are document that there are no adverse document contradicting the title to land.
I'm sorry, I'm unable to give you any marks for that. I am looking for a good title to land and how that may be derived. It could be derived by an enactment. It could be derived by grant, vesting order or conveyance from the state, a final judgment of a court of competent jurisdiction, a grant, an acquisition under customary law, conveyance, assignment, or mortgage which is at least 30 years old and establishes that a person is entitled to convey an interest in the land. These are the known means by which a good title to land may be derived. A good title. Now to your substantive question. Mountcrest University College. The common law forms part of the laws of Ghana. What constitutes the common law of Ghana as by Article 11, Clause 2 of the Constitution of Ghana?
Common law of Ghana, per Article 11, Clause 2, consists of the rules generally known as the common law, the doctrines of equity, and also the customary law, including those determined by the Superior Court.
And that is a comprehensive delivery. Thank you very much, Mountcrest University. Daniel Adewu. Now to you, here is your question. University of Cape Coast Faculty of Law. The President may execute or cause to be executed treaties, agreements, or conventions in the name of Ghana. What are the conditions to be satisfied before a treaty, agreement, or convention is executed by or under the authority of the President, become part of the domestic or national laws of Ghana?
Okay, so the treaty being assented to, agreed by President, could become valid when it has been ratified by enactment of Parliament or by a resolution of Parliament in order to domesticate such treaty into our national laws.
Thank you very much, but unfortunately I will not be able to award you the full marks because, yes, you are correct that it may be subject to ratification of by an act of Parliament, but in the second part, a resolution of Parliament. Now you are saying it and saying it to yourself, supported by the votes of more than 1/2 of all members of Parliament, and that was essential. I will award you 2.5 marks for that. Now to you, Mountcrest University College. And I expect you to be as precise as you have already started doing. Who was chair of the National Commission on Democracy set up to draw the 1992 Constitution of Ghana? Who was this individual?
Justice D.F. Annan.
That is correct. Justice D.F. Annan. Daniel Annan. Thank you very much. Now, to you, University of Cape Coast, Faculty of Law. The Constitution 1992 provide that a justice of the Superior Court shall not be removed from office except on certain specific grounds. Take your mind back to your Article 146. What are these grounds for the removal of a justice of the Superior Court from office?
Okay, so a justice of a Superior Court can be removed on grounds of stated misbehavior, incompetence, or infirmity of mind or body. Those are the 3 provisions that...
Thank you very much. I'll award you the full marks, even though I expected you to be more specific on the second ground, which is of inability to perform the functions of his office arising from infirmity of body or mind. So there must be an inability to perform the functions of his office, which will be arising or as a result of infirmity of body or mind. But you were absolutely comprehensive with the first ground, stated misbehavior or incompetence. Now to you, Mountcrest University College Faculty of Law. Please distinguish between mutual, and the eye is smiling, and common mistake.
Mutual mistake is a mistake that is made by both parties. It could be in respect of the subject matter, of the identity of the subject matter in terms of res extincta. It could also be in terms of the subject matter of the title to the contract. And in terms of mutual mistake, this is where the mistakes are made by a party across the level, but not by both parties. So for instance, Mr. Samson would like to offer his car for sale, that's BMW, and I accept thinking that it's a Range Rover. That constitutes mutual mistake.
Thank you very much. So you have made a distinction between mutual and common mistake, whilst you are still referring to mutual mistake, even for common mistake. Thank you very much. And that's a comprehensive answer, ladies and gentlemen. Now to you, University of Cape Coast Faculty of Law. States the main types of contracts in restraint of trade.
Contracts in restraint of trade could arise where, as a result of the geographical location of a particular, well, it becomes lawful where it restrains a particular party within a certain geographical operation, or where it is reasonable for that to be done.
The question is seeking for the types. How are these contracts manifested? There are two main ways in which they are manifested. That's what I seek from you. Your last attempt.
Okay, so they manifest when there is express stipulations between the parties in terms of contractual relations and in terms of intellectual rights that accrue to a particular business.
Thank you for the attempt. Because of your reference to business, I'll be kind enough to give you half of the marks. If you had the opportunity, what would you have said? Yes, Mountcrest.
In terms of proprietary interest in the business, and also goodwill and reputation.
So as regards contracts for sale, when we are talking in terms of a business, and there are also restraint clauses as regards the contracts of employment. So those are the two situations where they manifest, and that is where we sought to ask of you. Employment. You didn't use that word. So I'll award you half of the marks for that. Ladies and gentlemen, a round of applause for our contestants. At the end of the first round of this fifth contest between the UCC and Mountcrest University College Faculties of Law, Mountcrest made a total of 15 points as against University of Cape Coast Faculty of Law, 10 points. A round of applause, please. Now, ladies and gentlemen, welcome to the second round of this contest between UCC and Mountcrest University College Faculties of Law. This is the buzzer round. There will be 6 questions in this round. You are supposed to press your buzzer, and if you're able to do it first, you get a chance to answer the question in 30 seconds. If you answer correctly, you will be awarded 3 marks. But if you answer incorrectly, you lose 1 mark. There will be only 1 attempt to a question. If a team presses the buzzer before the question is over, they will be asked to answer it without the question being completed. Where a team presses the buzzer but fails to answer the question correctly, the opposing team will have the opportunity to press their buzzer to answer the question within 30 seconds if ready to do so. Now, how does the buzzer for Mountcrest University sound like? Thank you, and UCC. Thank you very much. So, ladies and gentlemen, if you are ready, we begin with our very first question. I'm a linguistic canon of construction, and I always help lawyers, students, and judges alike to understand the meaning of certain words by just considering my friends. Yes, UCC. And that is correct. What were you waiting for? Whispering to yourself. So I help lawyers, students, and judges to understand the meaning of certain words by just considering my friends I associate with. Nocita associates. Each of my friend is known by his or her association, and that is who I am. Nocita associates. Now to statement number 2. I am very popular in our courts. You will need me.
Petition.
Thank you, and that's correct. You will need me only when you want to commence an action such as divorce, nullity of marriage, presumption of death, dissolution of marriage, maintenance orders, and child custody orders. Of course, when there is election problems, I show up as well. I am petition. Thank you very much for that brilliant exhibition, Messi Donko. Now to our third statement. I am untrue statement made in good faith. Yes, Mountcrest?
That's innocent misrepresentation.
And that is correct. Innocent misrepresentation, Mountcrest. I am an untrue statement made in good faith with honest belief in its truth, intended to induce a party to enter into a contract. The party misled may bring an action for rescission of the contract and in some cases claim an indemnity against all losses or liabilities imposed on him by the contract itself, but he will not be awarded damages. I am innocent misrepresentation. And for someone who had just finished defining what represents mutual and common mistake, once I started reading the preamble, I suspected that they should press their buzzer first. Now, ladies and gentlemen, to our fourth statement. I am a defense in contract law. I am available where a party has been misled into executing a deed or signing a document. Yes, UCC?
Non ex factum.
The doctrine of non ex factum, not my deed. Thank you very much. I'm available where a party has been misled into executing a deed or signing a document of a class and character radically different from that which he intended to execute or sign, and that his mistake was not due to his own carelessness. Non ex factum. Now to our statement number 5, before the final one. Are you ready, ladies and gentlemen? If your neighbor insist on smoking tilapia in a homemade grill? Yes, UCC.
Nuisance or private nuisance.
That is correct. Nuisance. If your neighbor insists on smoking tilapia in a homemade grill and the smoke, smells and smut from the grill drift onto your property, dirty your washing, and stop you from sitting on your porch in the evening, who will we be talking about in respect of thoughts? That will be nuisance. Thank you very much. And now to our very final statement in this second round, the buzzer round. I'm a theory of punishment. I heard you first, but I'm surprised. I'm a theory of punishment. There are so many theories of punishment. Are you out to do a guesswork? Yes. What's your answer? Mountcrest.
Retributive.
I'm sorry, I'll continue. You had also pressed your buzzer already.
Utilitarian theory.
So that is guesswork, but correct. Thank you very much. I am based on the principle that punishment must ensure the greatest good for the greatest number of people. Thank you. And that brings us to the end of the second round, the buzzer round, in this contest between Mountcrest University College Faculty of Law and the UCC Faculty of Law. And it's brought to you by the kindest sponsorship of Sun Lodge Hotel, an experience worth repeating. Of course, there are also many others who are associated with this context. Voltic, naturally. If you're talking about mineral water, that is it. JoyNews, this channel, that's your most credible and reliable TV news channel. GCB Bank PLC, your bank for life. Amazing jewelry. And Mayjoy Blossom Ventures, that's where they ask you to drink fresh and live good. Logistics Movers, we move you there. Ghana Revenue Service and Goyle, Good Energy. Thank you once again, especially Sun Lodge Hotel. And ladies and gentlemen, at the end of the second round, Mountcrest University College Faculty of Law made 2 points. UCC Faculty of Law made 15 points. A round of applause for our contestants. Now you're welcome to round 3, which is the profound codes and personality identification. Here, there are 3 major questions, and you will be required to identify the personality the quote is attributed to, or also the case in which the quotation is found, and you do so within 30 seconds. If you answer correctly, 10 marks will be awarded, but there'll be 5 marks consolation for a partial answer. There'll be only 2 attempts to each question, and there's no negative scoring for incorrect answers. You will also have the opportunity to identify one personality within the legal fraternity, and this is a non-transferable round. Ladies and gentlemen, shall we begin now? And this time, beginning with you, the University of Cape Coast Faculty of Law. Article 130, Clause 2 of the Constitution 1992 therefore empowers any court below to refer to the Supreme Court for determination of any issue relating to Article 130, Clause 1 thereof. Now, it is very important to understand and appreciate that the Constitution 1992 is the fundamental and supreme law of the land, the provisions of which no other law is permitted to contradict. As stated in Article 1, Clause 2 thereof, this Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provisions of this Constitution shall, to the extent of the inconsistency, be void. Therefore, all courts, tribunals, tribunal institutions, including the government, and all individuals are bound by its provisions. Accordingly, all courts, tribunals, and indeed all adjudicating authorities in Ghana are obliged to apply the provisions of the Constitution 1992 in the adjudication of disputes before them. End quote. Who is talking and in which case?
Republic versus Mekankan. And the judge speaking, Edusa J.
That is incorrect.
Republic versus Regional Tribunal Espati Akosa.
I'm sorry, that is also incorrect. Is it because you are hearing regional tribunals or tribunals in the quotation, this very lengthy quotation? So if you had the opportunity, Mountcrest, who would you say is speaking here, and in which case?
No idea.
No idea. And that is Aqua Paul, JSC, as he then was, Justice Paul Aqua. And the case is that of Dumwa the second versus Chum the second, 1999-2002 Ghana Law Report at page 409. Now to you, Mountcrest University Faculty of Law, tell us who this statement is attributed to and the case in contention. For although it is settled law that in general, money paid under an illegal contract cannot be recovered, I do not regard the power purchase agreement as an illegal contract in the common law sense. Rather, it is a contract that is null and void and unenforceable for constitutional reasons. Restitution of money paid under such a contract should be allowed. Who is speaking and in which case?
Apaloyu, Adi versus Idran.
That is incorrect. Akpalu was long gone. You've been bailed out. Who are you thinking?
We're not sure, maybe the Balkan Energy case or Far Atlantic.
Don't say you are not sure. You have to be sure about what you do here. May sound like the Balkan Energy, but this is Far Atlantic.
Far Atlantic.
Close, isn't it? So this was Justice Dateba in Attorney General versus the Far Atlantic Company Limited, 2005-2006. Now to your question or statement. who is speaking and in which case. Apart from actions brought under Article 2 and those seeking prerogative orders, the President has immunity from legal proceedings in the performance of his functions under the Constitution. What the immunity granted by Article 57, Clause 4 does is to prevent the institution of such actions against the President personally. That is your clue. Who is speaking and in which case?
Amidu versus Kufuor, Pegan speaking. Amwasechi speaking.
You have exhausted your attempts, but you are correct as to what case is in reference. But who is speaking? Who will it be? Justice Akwa. You are correct about that. So you get half of the marks for getting a part of the question correct. So it's Justice Akwa in Amidu versus President Kufuor. You don't sue the president personally. You ought to title your suit in the name of the Attorney General. So, Mountcrest University College Faculty of Law. Who is speaking here and in which case? No proposition would be more out of accord with the hopes and aspirations of Ghanaians today than that a landlord who has spent no effort whatsoever towards that end should enter and collect at will the fruits of the labor of his tenants. We cannot imagine an arrangement more ruinous of agricultural enterprise, subversive of expansion, and consequently prejudicial to the national development than that. Too many landlords around coming to increase their rent when they have not done anything new to the property and so on. Who is speaking here and in which case?
Amisa Inison versus Atta.
That's correct. Thank you very much. Thank you very much. Amisa J.A. in Atta versus Eson. And that is correct. Now to you, UCC Faculty of Law. Who is this dictum attributed to and in which case? In the eyes of our law, a marriage by a Muhammadan, according to Muhammadan law, is at its best a marriage by customary law and does not affect succession to his estate, unless the said marriage is registered under the ordinance. End quotes. Who is speaking and in which case?
Olenu J in Alvin Ibrahim.
Forgetting Olenu, correct. As in, this was Olenu speaking in Kwachi versus Tuba, 1961, One Ghana Law Report. Now to you, Mountcrest University College Faculty of Law, and this is the very final question or statement. Who is speaking and in which case? Minerals in stool land are not part of the land. This is the shortest quotation so far in the entire contest. Minerals in stool land are not part of the land. That's why when minerals are found showing up in your bedroom, the state will come and take over. That will no longer be your land. Yes, Daniel Adewu And Victoria Entry.
Olenu, JSC.
Olenu is not in action anymore, and by this time, Olenu was long gone. So the answer to this is Justice William Atuguba in Okofo Sobing Khan II and others versus Attorney General and others, 2013-2015, 2 Ghana Law reports, and Olenu would not have featured anymore. Now, ladies and gentlemen, fix your gaze on the screens and let us know if you are capable of identifying who these individuals are within the legal fraternity. The University of Cape Coast, whose image do you see?
Mariama Osu.
And that is correct. Now to you, Mountcrest University College Faculty of Law. Who is in your shots?
Bedema JS. Bedde.
I'm sorry, not. You know him?
Is it Ni Ashu?
Yes, it
Ni
is.
Ashikote.
Justice Professor Ni Ashikote of the Supreme Court of Ghana. At the end of the third round, Mountcrest University College Faculty of Law made 10 points as against UCC Faculty of Law 20 points. A round of applause for our contestants. The law challenge. Now let's get to the very final round, the fourth round of the contest. And this is the rapid fire round. Each team has a captain, and you will be asked 10 questions in 120 seconds. You have 3 marks that will be awarded to you for a correct answer. Now, ladies and gentlemen, if you are ready, and this time starting with the Mountcrest University Faculty of Law. In Ghana, international treaties and conventions assume automatic operation. True or false?
That is false.
Thank you. That is false. Any question as to the existence or content of a rule of customary law is a question of fact for the court and not a question of law.
That's false.
That is also false. A seduced wife under customary law can be compelled to go back to her deserted husband. True or false?
That is false.
It's false. Magistrates or other presiding officers over the lower courts, as well as the registrars or judicial secretaries of the superior court, are appointed by the Chief Justice, acting on the advice of the Judicial Council and subject to the approval of the President. True or false?
That's false.
That is true. Article 145, Clause 3 of the 1992 Constitution provides that a justice of the Superior Court of Judicature may resign his office by writing signed by him and addressed to the Chief Justice. True or false?
That's false.
That's false. An issue arising out of a transaction shall be determined according to the system of law intended by the parties to the transaction to govern the issue, or the system of law which the parties may, from the nature or form of the transaction, be taken to have intended to govern the issue.
That's
true or false?
That's true.
That is true. The organization of the legal profession is entrusted to the Ghana Bar Association with the particular duty to organize legal education and uphold standards of professional conduct. True or false?
That is false.
That is false. Lease contracts, contracts affecting land or immovable property, contracts for the acquisition of shares in a company and marriage settlements are examples of necessaries as stated in Section 2 of the Sale of Goods Act.
That is false.
That is false. You are correct. Res ipsa locutor need not be specifically pleaded for a party to rely on it. True or false?
True.
That is true. Defamatory words spoken in the heat of passion are not actionable. True or false?
True.
That is also true. A round of applause for Mountcrest University College Faculty of Law for that great performance. Missing only one. Now to the UCC Faculty of Law. Here we go. A wrongful or forced arrest amounts to false imprisonment. Is this true?
True.
That is true. Malicious arrest and false imprisonment are but the same. Is this true?
True.
False. The secondary intent which is formed whilst doing an act, that is the desired result, is called the basic intent. Is this true or false?
Please.
The secondary intent which is formed whilst doing an act. Sorry?
False.
That is false. In Ghana, the age of sexual consent is 16. True or false?
True.
That's true. Equality before the law requires equal treatment of those similarly placed, implying different treatment in respect of those with different characteristics. This statement was first made in Tenade versus Electoral Commission. True or false?
False.
That is false. In Ghana, the office of the Ombudsman was first created in 1969.
True.
That is true. A document by which one person gives to another person authority to act on his behalf and in his name is called power of appointment. True or false?
False.
That is false. Power of attorney. In compulsory acquisition, the allodial title is not completely extinguished. True or false?
False.
That is false. Land granted to a family member by the family cannot be taken back without his knowledge. True or false?
True.
That is true. And this will be your very final question, University of Cape Coast Faculty of Law. Provocation is a complete defense to a charge of murder. True or false?
False.
That is false. And thank you very much for yet another great performance also by the UCC Faculty of Law. The Law Challenge. And at the end of the fourth round, which is also the very final round, Mountcrest made 27 points as against UCC's 27 points. The cumulative total marks for Mountcrest University is therefore 54 points. And that for UCC is 72 points.